I am one of the managing partners of Stratton and Reynolds. I am here today with my friend Kay Lawrence, and we are here to talk about what happens if you have a disabled child who is approaching age 18 and some things that you need to think about. Kay is a retired nurse, so she certainly has that perspective to bring. I'll let her tell you a little bit more about her experience.
Yeah, I've seen quite a number of families who have children who are intellectually disabled and obviously not able to make decisions for themselves. But when that child turns 18, legally, I believe they become an adult.
That's right.
And that leaves the families in a very tenuous situation in terms of making decisions for that child. So can you tell us a little bit more about the legal implications and what parents need to be thinking about to keep their family and their child safe?
Sure, absolutely. So any person that is turning 18, South Carolina then deems them as an adult. Prior to 18, their parents, or if there's a court order naming somebody else as guardians, those are the individuals who are making decisions for them, things like health care, signing contracts, making decisions about school and living arrangements. But when a person turns 18, our law says they're an adult and they should be able to make those decisions on their own. Obviously, in situations where you have children who are turning 18 that cognitively just are not able to make those decisions, most of our clients are looking at either one of two options. The first option, and this is what a lot of clients come in and talk about, is to do powers of attorney. Powers of attorney, we in South Carolina have both a health care and a financial. They're documents where you can name somebody to assist with making decisions. The problem with a power of attorney when it comes to individuals that have some type of intellectual disability is, number one, you've got to be competent to sign one. So the capacity required to sign a power of attorney is the same capacity required to sign a contract. I often tell clients, think about if you needed to put a roof on your house. What do you have to know signing that contract with the roofer? Well, you have to know I need a roof, you have to know this is maybe what kind of material it's going to be, this is the time frame in which they're going to build it, this is what it's going to cost. Obviously, for a power of attorney, a person has to understand all of those same types of things. I need a power of attorney, this is who I want to serve, this is what kind of powers they're going to have as far as making decisions. Oftentimes that's not an option. Sometimes it is, but it's just something to know. Number two, the problem with powers of attorney is it doesn't take away the rights of that individual to make those decisions for himself or herself. So for example, I had a client that had a child who was in their 20s, had cognitive disabilities. Child did a power of attorney, which was great. They still met somebody online. That person was interested in their disability check. Next thing you know, they're engaged to be married, and there was nothing that mom or dad could do about it, even though that child didn't really understand what marriage was and what that meant. They were being taken advantage of. But the power of attorney couldn't stop that. I tell people most of the time, I'm almost 40 years old, and most of the time I think I'm a competent adult. I have a power of attorney. Doesn't give anybody the right to supersede my own decision-making authority. So your other option, and the one that we talk to families about often, is guardianship. Guardianship is one of those things that really and truly you need to discuss in person with an attorney. You can do limited guardianships or full guardianships. There's a lot of options there. But at the end of the day, it's the process where the court appoints somebody, usually in this situation the parents, to make decisions for their child. Things like signing contracts, applying for marriage licenses, being able to decide medical procedures and such. It's a really important legal process, but certainly not one that should be undertaken without talking to an attorney about the pros and cons.
And that's a lot of really good information. I know for a lot of families that's a really tough transition, and they really want to be able to look out for their child in the best way possible. So that's a great, some great information. You should definitely talk to attorneys and really understand those options.
We highly recommend, if your child is approaching 18, come and talk to us, usually at least 60 days before they turn 18, so we can walk through those options. Again, if you ever need anything, feel free to reach out to us.